Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's presidential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. In late June 2024, I sat down and spoke with immigration attorney Eric Lee. Eric is a federal litigator with a focus on challenging wrongful visa denials by U.S. consulates. He was lead counsel on the decision just issued by the U.S. Supreme Court, Department of State v. Munoz, for which the litigation team won AILA's 2024 Jack Wasserman Memorial Award for National Litigation. Munoz was published only a week or so before our interview, and so as you'll hear, feelings were strong. In addition to the case of Ms. Munoz, Eric has used the courts to successfully overturn immigrant and non-immigrant visa denials on behalf of clients from multiple continents. And in 2022, he co-authored a law review article in the AILA Law Journal titled Consular Non-Reviewability, 50 Years Since Kleindienst v. Mandel. He has appeared on numerous panels to discuss federal litigation of consular denials, and his practice additionally focuses on complex appellate asylum claims. I say this a lot, but this was one of my favorite interviews. I hope you all enjoy it as well. At the end of the interview, you'll hear Eric mention how Ms. Munoz and her husband Luis can use all the help that they can get right now. And Eric asked me to share his email address, which is elee@diamantelaw.com. That's ELEE@DAMANTELAW.com. Also in the show notes. He also asked me to mention that, notwithstanding their very recent loss at the Supreme Court, Ms. Munoz and Luis's situation could still be cured if USCIS were to approve Luis's pending request for humanitarian parole. We saw something similar happen in one of the very Supreme Court cases that Eric and Justice Barrett relied upon in the Munoz decision, that is, action after the Supreme Court ruled against the non-citizen. So if anyone with authority or authority adjacent is interested in stepping in and equitably resolving the matter of Ms. Munoz and Luis, well, you know where to find Eric, and you know where to find USCIS. Now, onto the episode. Eric Lee, welcome to the Immigration Review Podcast. Thank you for joining me on this evening of June 28th, 2024. Thanks for sitting down and talking with me.
Thanks for having me, Kevin. Hi.
Hi. You and I have been talking now for, 2 years. This happens with quite a few people. It's one of the blessings of having the podcast. People kind of find me and I find them. I think I might have found you after your win at the Ninth Circuit in Munoz v. Department of State. Maybe it was the other way around. Either way, you and I have been talking about Munoz now for 2 years.
I know. It was a long time ago, feels like.
And I'm the least important person that you've been talking to Munoz about, but I am the person you're talking to about Munoz tonight. So that makes me the most important person for the next 45 minutes.
There you go.
I knew you a bit by reputation. I know you're a very smart person. I assumed you'd be a bit older, and I take that as a compliment. I mean, you're doing amazing work, and nobody can see it because this is an audio podcast, but you're a young looking dude
Yep, that's true. Can't help it.
with an old brain. And I can only imagine that after the last 2 or 3 years of litigating this case, you've actually aged about 10 years. So I guess you were 16 when all this started.
Well, I aged about 5 years while I was reading Justice Barrett's opinion in
My
this case.
goodness. Did you hear my summary of it on the podcast last week?
I did
You
not.
couldn't do it. You couldn't. I was wondering if you had. It was mostly criticizing the attorney.
Okay, well, I'm all ears.
Not at all. I did say that Justice Barrett's opinion in Munoz was respectfully written. Do you agree with that? It seems, and maybe the bar is so low based on the bickering that we've seen of late and just the anger that some of the justices seem to write these decisions. It didn't seem like Justice Barrett had that, but maybe you have a different opinion.
Yeah, I mean, I don't. Immigration lawyers were used to getting that BIA opinion where the panel says, "Of course, we recognize how horrible what happened to the client in El Salvador was, but we are so sad that we can't grant asylum and we've got to send them back to their fate." I mean,
Mhm.
so I don't. On the law, this was a very, very right wing decision, which has broad implications beyond immigration. Could care less about the tone of the decision as opposed to the content of the law, which is extremely concerning.
That's completely well taken. For those of you who aren't Supreme Court watchers and who didn't listen to my summary or haven't seen it on the blogs, Eric Lee is the attorney who has been representing Miss Munoz for years now, including before the Ninth Circuit, I assume the district court, and one of the rare immigration attorneys who did himself take it up to the Supreme Court because that is what Miss Munoz wanted him to do. So he just finished arguing before the U.S. Supreme Court in the Department of State v. Munoz decision. It was a loss for the non-citizen, but all jokes aside, had nothing to do with Mr. Lee's representation of Miss Munoz, or quite frankly, even the facts of the case. Eric, usually for these interviews, I do a decent amount of preparation. I haven't really prepared at all for this, except for reading the Supreme Court's decision. So I just want to kind of let you go at it, provide the unfiltered opinions that you have, and talk about it in general.
Well, can I start, Kevin, by just thanking a couple of people because what I want everybody to understand, and that's what you've said is nice, but this was to call it a team effort would be an understatement. Alan Diamante is my boss. He was the one who decided to take this case because he believed in it, even though the case law was not favorable. We knew it would be an uphill battle. The National Immigrant Justice Center, Charles Roth, Karen Zwick, Colleen Cowgill, Mary Georgevich, and Richard Calderon were at the Supreme Court stage. Just absolutely could not have happened without each of their work. I mean, the NIJC basically put aside a lot of the other cases that they were working on, really important litigation, jumped on this case because I asked them, and they just did it, and
Yeah.
they put their whole organizational abilities into this. So Erwin Chemerinsky at Berkeley Law, of course, was on the papers. So I wanted to begin with that. I mean, that's the most important. This was 6 months of intense every day. The organization of the amicus briefs, the moots that we did to prepare for this, all the people who helped along the way, who drafted the briefs, who were at the firms that drafted the briefs. I mean, there were hundreds of people involved in getting this case ready, and thank you if any of them are listening. I mean, Sandra, Luis, myself, nobody will ever forget the contributions that they made to this case.
I said it actually last week when I did the case, and I didn't even know half of what you just said, but I do know that the immigration community really came together on this for the mood. I knew about Charles Ross' involvement with the amicuses. The ABA and Sidley Austin came in with an amicus, and it was tangentially related to that, and so much amicus, and it was so important to the immigration community. It's always great to see that, right? How this community does come together and support one another. And
Mariko, I'm sorry, Marie. As you're mentioning this, I've got to say Mariko Hiroshi, who was at IRAP, Kate Gettle, who was at
Yeah.
AIC, Leslie Dillon, Sabrina Damast from Ayla. Yeah, this was. I mean, I could go on, but on the amicus, they were those four in particular.
Thank you for saying that. And I hope some of them are listening. And I do it on the podcast all the time. It's important that people who do work get the recognition. So how did this all start? Miss Moon, and throughout this, and to be clear to everyone, I did invite Miss Munoz to join you tonight, and I can understand why she wouldn't want to be on this. But through both me summarizing her case and hopefully through this interview, her personal story and that of her husband will come out because so often in law and Justice Barrett's decision is case in point, we lose sight of the actual people who are being affected by our legal theories.
Yeah, so let's start with Sandra and Luis. Sandra Munoz was is the daughter of an Army veteran who was fought in combat in Germany in the Second World War in the U.S. Army. We don't know very much about him because his Army records were unfortunately burnt, but we do know that he was in a tank unit and that he was in Germany in 1944. So, and then Sandra's mother was I hope I'm not getting the company wrong, but she was a Sears warehouse worker. I'm pretty sure it was Sears in Los Angeles. And so Sandra was born in East LA. She's as American as you can be. She actually was in the high school class, which was featured in the movie Stand and Deliver.
I
I don't
haven't
know
seen
if
it. No, I haven't seen
yeah,
it.
actually, me neither. But Jaime Escalante is a very famous in LA in particular. This is a big deal. But they made a movie. It won awards, and Sandra was in the class. It's about a high school teacher who it was made in the '80s. A high school teacher who has a difficult working class and some gang issues in there, and he elevates their consciousness and teaches them math and he wins them over. Anyway, Sandra was in the class that the film was actually based on, that specific class. And Sandra became a workers' rights lawyer. And that is how she refers to herself. She is a civil rights lawyer as well, but she will correct you if you say that. And she'll say, no, I'm a workers' rights lawyer.
No.
She's very proud of the upbringing that she comes from, and rightfully so. And she built a law practice. She's won some very, very significant decisions against some of America's largest and most exploitative corporations. She has a practice that was why when Justice Roberts said in the oral arguments, well, she could just go to El Salvador, can't she? She's not really separated from her husband. I mean, she not only is she is from this country
All right.
and has a right to be here, but I mean, her whole life is here. Her practice, her friends, her family, and Luis got here in 2005, and he's a soccer guy. He loves playing soccer. He plays pickup games, and he and Sandra met in 2008. They got married in 2010. Waited a few years, and then they started the process to get his green card. He's got no criminal record. Got approved for his waiver of his unlawful presence, and that's of course where the story begins legally.
Before we get to how the story begins, if when you talk to Miss Munoz, let her know that actually Ira Kurzban would refer to himself originally as a workers' rights attorney. That is how he started, and then he kind of fell into immigration in the 70s. So she's in good company with the godfather of immigration on that, and how that is so impactful and important in civil rights law that so often, even ACLU, it starts with workers' rights. So Ms. Munoz is, like you said, as American as it gets. Not that it really matters, right? I
No,
mean, once you're a citizen, you're a citizen, but I think that's an important thing to remember. And just to lay the groundwork, you talk about he got his waiver. It's no small thing to get an I-601A approved, as you know. You need to show the extreme hardship. They're backlogged 4 years. They're not cheap. They do get denied, and he only needs it because Congress changed the law in 97, and now, if you entered unlawfully, you can't just adjust through your U.S. citizen spouse. You need to go get your inspection, admission, or parole. And oh, by the way, if the Biden thing that was just announced goes through, right, Luis never has to leave.
right.
He gets his parole in America because he has no criminal record. So he gets it. He gets the 601A. He leaves to go sit for his consulate interview, and then what happened?
Right. So, and just brief aside, I mean, not all he would have he had 10 years residency at the time he left, which is what we've been told is in the new parole in place
Hmm.
program.
Right.
He didn't have a criminal record, and yeah, he passed a DHS background check at a time, by the way, when DHS, where the regulations said DHS had to determine that you weren't likely to be inadmissible for any other reason, even other than your unlawful presence,
Right.
and that you weren't a public safety threat or a threat to national security. So, based on that, Sandra and Luis go together to El Salvador in the spring of 2015. It's hard to believe it's 10 years ago almost. And thinking, this will be a little vacation. I mean, they thought, well, this is going to be a quick trip. Luis has never been involved in criminal activity of any kind or gang activity, to say the least. And at the interview, it's not entirely clear to us still what did it, but we do know that the tattoos that he has were what initiated the suspicions. Basically, they profiled him based on his tattoos and decided that he was a gang member.
But you didn't even know it was the tattoos at first. I mean, you assumed that, but it's not like they said, we don't like your tattoos.
Right. So what happened was, I mean, it was basically because he's got such a clean record and nothing in his history which might otherwise indicate it. It was like prior counsel who did the consular processing at first before this was in federal court took as blind a guess as they possibly could,
Yeah.
threw the dart at the wall, thinking maybe this is somehow responsive. Didn't even know what gang he was supposed to be a part of. They didn't say in the initial denial letter, which came in December 2015, anything other than a citation to the statute, which is the broadest
Hmm.
language you could imagine, any
Right.
other unlawful activity.
You're coming to the United States. We think you're coming here in what, your 40s, 50s to be an active gang member. And they just cite to the provision. They just cite to the inadmissibility statute, right?
Yeah, it's like Minority Report, I think, is the movie
Mm.
where they predict your criminal activity based on, whatever. And yeah, it even says that if you're going to enter to commit unlawful activity, even incidental to your main purpose for coming in, which is everybody could be barred on that basis. I mean,
Yeah.
who doesn't jaywalk
Yeah.
every now and then? So that's what they said. Prior counsel did everything they could. They really scrambled without knowing anything about the basis. They tried to get some exculpatory information, evidence submitted. They tried to, ask the embassy to reconsider and ask for more information. Hey, give us something so that we can try and rebut. Give us enough
Yeah.
information so that we can try and disprove it. Maybe they have the wrong guy. Maybe there's another Luis Asensio who's actually doing unlawful activity. So they submitted a gang expert affidavit saying that that if the tattoos were an issue, they weren't part of it, or they weren't gang related, rather.
We can just all, this is the worst nightmare of Sandra and Luis. This is also the worst nightmare of any immigration attorney who's put in good faith sent their client abroad. No immigration attorney will promise that they can get in just because they got the 601A, but it's supposed to be pretty dang assured. And this is what the basis of the ABA's amicus with Sidley Austin
Yeah.
was, is that this prevents immigration attorneys from doing their job. If you can't advise your client, and now you're dealing with this absolute crisis from across the world, not across the world, but from different countries with a consulate that you can't even step foot into. You're not even in country and you're guessing.
I mean, think this was what Walter Raleigh in the Tower of London, was fighting over, the right to confront the evidence against you, and permanent separation, permanent from your family, from your community, from your wife, permanent banishment from your adopted home country is worse than many misdemeanors that one could be charged with and have the full panoply of due process rights. So it's an absolute nightmare. And then you have on top of this arcane rule rooted in the most vile precedent of Chinese exclusion and the national origins quota and all of this that says that you don't even have the right to a day in court to challenge denials when they're clearly wrong, like this one.
The doctrine of consular non-reviewability, which is what this case really becomes, and we're gonna, of course, hit that and dedicate the rest of the podcast to it. But before we leave Sandra Louise, because like once we get into that doctrine, it becomes legal. The case can go either way once you're getting into doctrines and what is right, what is not. And but if we lose the facts, we lose the most important part to me, and really why the legal doctrine matters. And I don't want people to forget that at the middle of this is Sandra and Louise, and you have it in your briefing and everything. You've stayed, of course, focused on that as you argue this history, beginning with the Chinese Exclusion Act and all that. And but before we pivot, I'm just curious, not that it really matters. What are the tattoos?
Oh no, we listed those in the brief. Number one is Sigmund Freud. He's got a tattoo of Sigmund Freud.
Is his
Yeah.
mother still alive? I mean, that could be that could be criminal activity.
Maybe that was part of it. Yes, she is actually.
Okay,
but
that was a bad joke.
Yeah, no, but maybe it was. I said maybe the MS-13 is Jungian. You know, they really don't like Freudian psychoanalysts.
Mm.
And if we'd have known it was MS-13, we could have proven that to the embassy. You know,
Right. You would have put a gang member on the stand talking about his psychological idols.
exactly. Yeah, the other one, there's a tribal tattoo with a paw print. There's the theatrical masks. There's some dice and playing cards on one of those, and Our Lady of Guadalupe. You know, the emblem of Latin American, an emblem of Latin American culture and Mexican and Central American heritage, and of Catholicism. Those are the tattoos.
You end up getting gang experts and tattoo experts. It seems like you're very clearly saying Luis isn't a gang member, but like, what is the allegation with these tattoos? What could it have been? Is there just really, we have no idea.
You know what? I've seen cases where it's LA, you know, where it's the Dodgers logo that maybe does it. I mean, it's just, who are we kidding? It's racial profiling, and they use the fact that there's a binder in the embassies that has tattoos that they've found on the bodies of gang members. And, you know, what's the difference between street life tattoos, which have no connection to criminality, and actually, I mean, you know, we have never argued that the government has to let someone in if they've got MS-13 tattooed on their forehead or something. That's another case. But don't forget, tattoos are pure free speech activity.
Yes, absolutely.
And you know, the fact that Luis got tattoos when he was a kid on its own, I think that's the main issue. You know, no, without any other indicia of criminal activity, the fact that they only point to activity which is the opposite of criminal, which is actually protected by the Constitution, is something which defies logic.
It's a fantastic way of framing that. And we all know that the Supreme Court loves the First Amendment these days. So that's a very good way to frame it. Like, just to be clear, the 601A waiver, I mean, 10 years, that inadmissibility bar for unlawful presence is 10 years, and that's a big deal. Nobody wants to be separated 10 years, but this inadmissibility vague, we think you're coming to do criminal activity because you have tattoos, that's permanent. I mean, the tattoos are never going away. Maybe you can come back and convince another consulate officer, but like, this is a permanent bar case.
Yeah, it's in the joint appendix. The letters that Sandra and Luis were sent said that this is permanent.
Wow.
I mean, the word permanent comes up multiple times. I was a bit surprised when the Solicitor General said at oral arguments, "Oh no, it's not permanent."
Right.
You know, so that was news to us.
There is the doctrine of consular non-reviewability, and I actually just outlined what I'm going to do this week for the Loper-Bright Chevron decision. The doctrine of consular non-reviewability, just like Chevron, the Supreme Court just said there is no stare decisis and they can do whatever they want. Just like that is a judicially created rule. Is it not a judicially created rule that gives immense power to the executive? More power than Chevron gave to the executive. By definition, non-reviewable power to the executive in the guise of the Department of State.
Yeah, Chevron is an interesting decision in terms of its impact on this line of cases. And And before we get kind of to the merits, I just want to make a point preliminarily about how this case got to the Supreme Court, because the Biden administration petitioned for cert.
Yeah.
We won below,
Yeah.
and we did not. We made every effort we possibly could to try and convince the administration that this was a bad idea with repercussions that would go beyond immigration. You see some of what those repercussions might be in Justice Sotomayor's dissent in terms of the impact on other unenumerated rights. Even Justice Gorsuch noted that the administration's positions were basically adopted, word for word by the majority. The positions that the administration took, not only by by petitioning for cert, but the positions they took in their briefs, the positions they took in the argument, were extreme, and they own this. This decision is the responsibility of the Biden administration. Obama State Department was the one who denied the visa here. Trump continued to fight. The positions of the government in this case haven't changed over these three administrations, which I think is an extremely dangerous but important point that people have to understand.
How did you win at the Ninth Circuit and get out over consular non-reviewability in the first place? I think that's an important background before we get to the Supreme Court.
Well, two things. First of all, consular non-reviewability doesn't exist. And number two, it certainly doesn't exist for U.S. citizens. And this doctrine is something which is rooted very, very explicitly in its two sources are Chinese exclusion and the 1924 National Origins Act and the kind of mood in Congress and in a couple of courts of appeals at the time. The National Origins Act, as you know, was the act by which which was essentially enacted by the eugenicists. Dan Okrent has a great book called The Guarded Gate, which is about this issue. I recommend everybody get it and read it, describing how the eugenicist movement and people who ended up being open admirers of Hitler passed this bill to prohibit Jews from Eastern Europe and Southern Europeans as well from immigrating to the U.S. So these are the two, and the Chinese exclusion, of course, was just based on the most clear racial animus.
I don't understand how it could be. The title is so clearly non-racist.
Yeah, but not just that, it was sort of wafting in the background, but like the rationale of Che Chang-ping and Nishimura Ekyu in some of the cases that the government has cited in this case in its papers are horde of invading Asians who will not assimilate to America, and always directed at the laborers specifically, which is interesting. There were exceptions made for merchants, but never for the workers coming to build the railroads and dying by the thousands. So those are the roots of this. I thought it was interesting actually that, and someone should do something with this if they're listening. The Representative Grijalva sent a letter to the DOJ recently and asked the DOJ for its position on the applicability of the insular cases on colonial powers, et cetera, and powers over Native Americans. And the DOJ essentially repudiated the insular cases. Now, if you repudiate the insular cases and if you repudiate Plessy versus Ferguson, you've got to repudiate the Chinese exclusion cases because they're based on this theory that the power over immigration is necessary as essentially a war power to keep America pure. I mean, these are not my words. This is to keep it racially clean.
Well, it seems like a similar rationale being used in Texas and other states right now for the states to create their own immigration policies. We're a nation at war that's being invaded. That is essentially the rationale to get around the Supreme Court's Arizona decision that's only a decade old, right? I mean, history repeats itself. History never goes away.
And it was what we heard at the debate last night in Atlanta, too.
I actually couldn't watch the debate. My wife is pregnant, and we feared that watching it would induce labor. We were stressed out a little bit, but we need that.
If anybody's over a week late, go ahead and get on YouTube and watch it.
No, my goodness. You say that the doctrine of consular non-reviewability is not really a doctrine. It's not really a thing. There is Kerry v. Din. There is the cases that Kerry v. Din relies upon. It's been 100 years. It's pretty dang hard to sue the Department of State in federal court? How did you get to sue them and finally get some information about why Luis was denied his visa?
Yeah. Well, first of all, this statute, the any other unlawful activity statute,
Yeah.
the magistrate in our case was not happy with the breadth of the language, and so she denied a motion to dismiss the case that the government filed. And after that, I mean, this was almost 2 years after we filed the lawsuit. The government comes back and gives us this affidavit from an advisory attorney in the State Department, which says, "Oh yeah, he's a gang member, and he's a member of MS-13." I think where a lot of people get in trouble when they litigate these cases is that they try and frame it as though they simply disagree with the factual conclusion that the officer reached, rather than framing it as a purely legal or mixed question. And I do think that the decision, by the way, that came out leaves a lot of, I mean, it affirms Mandel, which is the 1972 case that is the sort of only case which maybe acknowledges this doctrine, but it doesn't really use the words. And Trump against Hawaii, the court didn't acknowledge the existence of the doctrine. So I think it's still an open question. I mean, Barrett does reference it, and this is certainly not an opinion that we like, not the least because it keeps our clients apart. But in many ways, it could have, I think if it were better written, it could have closed the door on additional litigation, but I don't really think it does.
That's interesting what you said, because, I'm going to dumb it down, but you kind of won on procedural grounds. You said people want to always talk about the facts. You win at the Ninth Circuit. You get around the doctrine in part, right? It's been a couple of years since I read it, but state didn't tell you the reason, a sufficient reason soon enough for you to be able to ascertain whether or not the Department of State denied the visa for some impermissible reason that Kerry v. Dinn still leaves open, or for you to be able to do anything. It's really a procedural win at the Ninth Circuit, and it's kind of tethered to the vast ambiguity of this inadmissibility provision, is it not?
It is. That's right.
If you had gotten a denial based on a false claim to citizenship, that would give you the factual basis in the inadmissibility provision. Do you think you even win at the Ninth Circuit?
Well, in the absence of other facts that the government refused to accept exculpatory evidence, or the evidence was so overwhelming that it's impossible to conclude otherwise, and that proves bad faith, based on Justice Kennedy's concurrence, which is no longer the I mean, we'll have to talk about that and see how that shakes out in future litigation. But yeah, at the time we litigated this case, Kennedy's concurrence in Dinn, and that was a 3-way split there, which was very confusing, placed a lot of emphasis on whether the statute itself contains a discrete factual predicate. In other words, whether you can, as you just said, whether you can tell what you did just by the language in the statute itself.
Right. The original sin is the doctrine of consular non-reviewability, in which these consulates are fiefdoms unto themselves and don't have to show their work and don't have to give you the opportunity. And by the way, LegalNet itself, you can't even bring a factual challenge, right? You're going back to the consulate with extra evidence. In this case, there is this administrative appeal, this pseudo appeal process with LegalNet, as we know, but if you bring a factual challenge, they're going to just say apply again. They're only concerned about legal ones anyway, and you can't really sue them. You win at the Ninth Circuit based on procedural grounds, and by win, that is, you get around the doctrine of consular non-reviewability, and now you're in full-on suing the agency land. The win is just and you get your day in court, and because you get your day in court, because the government has to do more than just say no and cite to a statute, what happens?
The Biden administration petitions for cert.
Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes.
I mean,
it was on that preliminary issue. You never even got to the merits. There was never even a finding that state violated the APA or some other statute in denying this visa. It was just preliminarily getting around the doctrine in the first instance is when you go to the Supreme Court.
Yeah, I mean, we argued in our opposition to the cert petition that this was all, too early in the litigation otherwise we could be back up there.
It's kind of like qualified immunity in that sense, in that we want to stop federal court. We want to stop federal court litigation so bad that if you allow federal court litigation, you can take that denial of consular non-reviewability, you can take that denial of qualified immunity directly up to the appellate body.
Right. Yeah, which isn't really comforting from the standpoint of making sure that mistakes aren't made. I mean, actually, Senator Grassley, who's not known as an opponent of the executive branch and of attacks on immigrants, has raised public concerns about one consular officer who has been posting, pro-Hitler YouTube videos and such. You can Google search for those and find Grassley's letters to the State Department. Some of these officers are 21, 22 years old. Doing visa interviews is not what people who enter the Foreign Service want to be doing for their whole career. They're doing them. There's a lot of them. The variation between the people who are doing them is such a crapshoot for such an important thing. It would, for lawyers, it's like if half the people grading the bar, hate lawyers and don't want any more, or I don't know if it's half or more than half. I mean, that would be unfair. There would be lawsuits about it.
Yeah, we've got a Hitler-loving one apparently, but putting him or her aside, every consulate officer I've ever met actually is a good person, and they care about America. Maybe they don't want to be a consulate officer. They're certainly overwhelmed. The statistic is, they only have a couple of minutes per visa interview, and just mistakes happen. Mistakes happen if you've got 5 hours to review a case. You got 5 minutes to look at someone. I always tell people at these interviews, like, you're getting judged in the first 30 seconds. You go and they're getting a feel about you for the rest of your life. To make an entire doctrine based on the idea that mistakes don't happen is nuts, because that is what we do as a country. We litigate when a mistake happens, and that is what helps mistakes from not happening or being remedied. And so it is a bit crazy, even assuming the best of these consulate officers, which personally I do, and I mean I think you do too, other than this Nazi.
and whoever denied my client's visa. I agree with that, and the fact that the main point to make is, although I wouldn't downplay either this is a political system which is, got Congress, which is a third full of people who supported the coup of January 6th. So there are people in the federal government who are just straight up dangerous from the standpoint of the defense of the most basic constitutional democratic rights. But no, I mean, certainly the conditions in which these life-changing decisions are being made, even for the best and most pure-hearted consular officers, are not the best. Right. And just to make one more sort of historical point, I think in 1921, there was a Red Scare going on. This was right after World War I. There were mass deportations taking place in the Palmer raids, and Congress passed this Emergency Quota Act, which then became 3 years later the official, lasting National Origins Act. And that was when the legislation changed so that visas were required to travel via steamship from Europe to the United States. So it wasn't until then, and the very explicitly the reason for this, well, there was the public reason was that it was unfair that people were coming from Europe, and it just happened to depend whether you made the numbered quota, whether your boat got to Ellis Island before somebody else's boat. That was one of the public explanations that was given in Congress, but the subtext was it prohibited groups like HIAS, the Hebrew rights organization that submitted an amicus brief in our case, but which was very, very prominent in defending the rights of immigrants arriving in the United States, was to essentially prohibit the families of these immigrants from Europe and the rights groups from filing habeas petitions to get people out and to keep them in Europe. So
Wow.
there's not like a logical reason why it is this way. It's just because of that legislation from a very, very dark period of history.
So you get around what is essentially qualified immunity in immigration. The Ninth Circuit tries to go en banc. I believe 10 of the judges wanted to go en banc. It survives the challenge. The Biden administration decides to take it to the Supreme Court. Supreme Court decides to take it. There's a different composition on the court now. Justice Kennedy is not there to concur and push the law. Justice Barrett, correct me if I'm wrong, is essentially saying, whether you agree personally, we all agree that Luis doesn't have a constitutional right that can come before the Supreme Court sitting in El Salvador, or at least it was stated by Justice Barrett that the parties were in agreement, whether you begrudgingly came to that. So this travels under Ms. Munoz. Sandra, the U.S. citizen, that's why it's Munoz versus Department of State maybe Munoz. Did you need a constitutional right? Is Justice Barrett correct that you can only talk about this if Ms. Munoz has a constitutional right to defend?
Well, no, and just it was Munoz et al. Luis is a named party, and the district court, we argued that Luis has due process rights. The district court ruled against us, and that was just not, the Ninth Circuit did not consider that issue. That was not before the Supreme Court. Justice Barrett's got a little bit of dicta in there in the beginning, but that's not binding. Look at Plasencia, a O'Connor decision from the 80s, late 80s, I believe. And that was where an LPR left the U.S. to commit a crime, to engage in smuggling. And they put her in exclusion hearings, and the Supreme Court held that she did have procedural due process rights. There's another line of cases. I'm not going to get too far afield with this. There's interesting cases. There was a guy who got on a boat, Huang Hai Chu, gets on a boat. He's he's a permanent resident. He gets on a boat from, I think, San Francisco to New York. And as the boats, forget exactly how this happened. Maybe I'm confusing the cases, but in any event, he's barred when he comes back into the U.S. And the Supreme Court said, this was in the same year as it decided, a couple of weeks after it decided Mazzei, which is one of the really bad cases that the Supreme Court did not cite here, actually, interestingly. And the court said that it's like a fluty type argument. If you're not leaving the country to engage in illegal behavior, and if it's brief, then the Constitution doesn't just wash away because you left.
That's a flat out due process right. I suppose the fluty stuff, which is old law anyway, and the statute has changed. Now you have a due process right to be able to keep your green card, to not have it taken away arbitrarily, to paraphrase what probably is the basis there. And so in that sense, I mean, due process is a free-floating right that U.S. citizens enjoy and that certain non-citizens also enjoy. Why is it the case then that Ms. Munoz needs to be defending a constitutionally recognized right, as Justice Barrett says, the right to live with one's spouse in her country of choice, or something like that? Why do you need a second right for due process to attach, or is Justice Barrett just wrong?
Well, I mean, whether I think she's wrong or not, she's the one who gets to write opinions which have the effect of law of the land. But I would put it this way: Justice Barrett's decision does not overturn Mandel. In fact, it explicitly acknowledges that the doctrine of consular non-reviewability does not apply to citizens. And she attempts to, in the last pages of her decision, and there's a lot of ways to read some of what she says there. But one thing she does not say is that Mandel is overturned.
And so that's why you want Miss Munoz. If you can have this be about Miss Munoz, then the doctrine of consular non-reviewability is a red herring. And because it doesn't apply to US citizens. And we have Justice Kennedy's case law and the precedent before him that's saying that the right to marriage is a fundamental right. And so that is kind of how you try to get around the doctrine by using the US citizen, and she's trying to further her right to marriage. Is that correct?
Yeah, basically, except with the minor caveat that Justice Kennedy's concurrence from Din didn't say that there's a right to marriage. It just says,
I'm talking Morrow
oh,
Bergefell
I
Kennedy.
see. Yeah. Well, and they were decided 11 days apart in 2015.
Were they?
Yeah.
Oh.
Carrie Abrams at Duke has a really great article on that, which is fascinating, which everybody should read. But yes, based on the Din framework, we believed and we litigated it along the lines that you need a constitutionally protected liberty interest. I think after Chevron, the statutory argument becomes very interesting as well.
Yeah.
That there's this idea that that the court has just acknowledged the existence of a doctrine which says that the courts have no role whatsoever to play and the executive can do whatever it wants all the time, which I don't think is what the ruling actually stands for. But then a week and a half later,
exactly,
rule in Chevron the exact opposite. Well, but what's funny is that first of all, yeah, I mean, if he could have gotten an investor visa, none of this would have been a problem. But I don't think they check the tattoos of those guys. But maybe they do. But the serious point though is, I mean, Mandel was the case where there was a Belgian guy who was a professor and had some generally left-wing views, and the attorney general denied a waiver of his inadmissibility, and a bunch of American professors, including Herbert Aptheker and Noam Chomsky, sued, claiming that it was their First Amendment rights to hear him speak.
Mm.
And the court said that was the Supreme Court, the Berger court, held that was enough. The fact that we've gone so far from Berger now, but
well, let me just parse that out. So they are exercising those U.S. citizens are exercising their First Amendment protected right to listen to this guy speak. Hence, they can challenge the Department of State's denial of a visa. Ms. Munoz is trying to exercise her equally important, under Supreme Court jurisprudence, right to marriage. And that is why Justice Barrett then says that's not what she's actually trying to further. She's trying to further this more distinct right.
Yeah. So first of all, if there are any law professors out there listening who are having a conference about this decision and want to invite Luis to attend to speak at it, that would be
that's the most beautiful thing I've ever heard. Well, how would a district court even get around that?
I don't know. Maybe we'll have to find out. But what I would say about Justice Barrett's decision is that it's a total mishmash of what we were actually asking for. We never claimed that there is a substantive due process right to guarantee that your spouse gets into the country if you're a citizen and your spouse is undocumented.
Mm-hmm. Of course.
Actually. And so she flips it around and says that that's what we were doing. All we were asking for is the chance to go back to the consulate. Now that we had this in litigation, we finally learned that a lot of specific information. Yeah, we always try and get as much as we can to try and represent our clients zealously. But we learned that it was because of the tattoos. We learned that they had some law enforcement report that they submitted ex parte information about to the district court, and gave us like 10 pages of total black, redacted top to bottom of the page. And so we wanted to go back and have the chance to respond to that now. That's all we were asking for. And so It's annoying when you litigate a case for 10 years and you make very careful arguments and you try to work them through and you work with a large team and you figure out the best argument, and then a decision comes out which says that your argument was something other than what it was.
Yeah.
There's nothing I can do about that now. But what I do think is interesting is that on June 18th, Biden spoke at the White House about the new Parole in Place program and seemed to essentially acknowledge that the consular interview is very, very unfair, that it should not be required for people who lived in the country for 10 years. And it seemed to, on the one hand, have been a total vindication of the arguments that we were making. And on the one hand, it was very bitter to hear for all of us because it was the exact opposite positions as his Solicitor General had just argued in this case. I mean, not to take too much time, but Biden said, and you can find the transcript on the White House website, he said that the consular interview is the type of, quote, problem that makes our immigration system unfair and unjust, end quote. And that eliminating this requirement is a, quote, better way. It doesn't tear families apart. Under the current process, undocumented spouses of citizens must go back to their home country to fill out paperwork and obtain long-term legal status. They have to leave their families in America with no assurance they'll be allowed back into the United States, end quote. So, I mean, they should let Luis in because he would qualify under this program, and many thousands of families who are also separated would also qualify.
That's very frustrating. I also want to be clear, and you mentioned it yourself, and we keep using Justice Barrett as shorthand, but this is a majority decision. The justices who are in the majority signed on to it. It's Justice Barrett's authorship, but this is not Justice Barrett. These are the positions argued by the U.S. government as well. This is the decision that the majority wanted to issue, and largely the decision that the Solicitor General wanted to be issued. So, to the extent we're using Justice Barrett's shorthand, it's not for any other reason, but that's just how lawyers talk.
And the fact that Biden made this appeal to the extreme right of the court right now, I mean, today we get these three decisions. We get grants pass, homelessness is illegal, can be criminalized. We get Chevron, no more environmental regulation. We get a little bit of a reprieve for the January 6th defendants. I mean, every day it's like another blow to democratic rights. And the administration, of course, knows that this is the composition of the court. Biden's telling his own, when he's doing fundraisers and he's warning about the court. The Democrats in the Senate are asking Roberts to meet and talk about Alito and his flags. And yet Biden made a deal with the people. He knew that he was going to get what he wanted. That's why they petitioned for cert. And so you have this situation where the administration, in alliance with the Thomas, Roberts, Alito wing of the court.
The people at Oil would say, who I'm sure petitioned the Solicitor General to take this case, would say that the Ninth Circuit was an outlier and that they are simply protecting the rule of law and being nonpartisan. You don't think that's the case?
No, I don't think that's the case.
You think this is what the Biden administration wanted, and not the view of the legal opinions of the largely non-political DOJ?
I'm sure they all agreed. I mean, otherwise, why is this case taken 9-10 years of litigation? Yeah. They asked in their brief. I really want to stress this point because if what you're saying is true, then the administration did not need to argue that there was not even a liberty interest involved here through the right to marriage.
Right.
And the fact that they tried to do a little dance in the oral argument about this, but the fact is that they dangled to the court asking for a rule that would say that no citizen spouse can ever bring a claim because there's no liberty interest. That was their argument in their briefs.
That's horrifying. We see that Justice Barrett's footnote at the end says that the precedent about the right to marriage and all that is not being questioned, but you bring up a good point that based on the Solicitor General's arguments, they could have taken that bait and made this the first step in taking down Obergefell, mixed marriages, and all of that stuff.
Yeah, not just marriage, but this is the fact pattern here is so similar to the fact pattern in Loving Against Virginia in one important way. Obviously, there are differences, but in Loving Against Virginia, the Commonwealth of Virginia said, "What are you talking about? We're not violating your right to marriage. You can go live in Washington, D.C., where your marriage is valid. You can
Yeah.
go, and then you can come in, and you both can come in and spend time with your family in Virginia on the weekend and do whatever you want. All we're preventing you from doing is cohabitating." And in fact, the state court of appeals in Loving said that the gravamen of their offense was cohabitation. And the idea, I'm getting a little bit personal here, but if the federal government told me that I couldn't live in the same house as my wife and that she had to live 3,000 miles away, they damn well better give me a reason and the right to fight him in court.
Obviously, Miss Munoz did not succeed. Luis is not getting his day in court. She is not getting her day in court. Before we wrap up this very engaging and very interesting interview, I have two questions. Where does Miss Munoz and Luis go from here?
I mean, it's just a horrible, horrible situation that they're in, and it's very difficult to think about because I don't know what kind of marriage can survive this kind of thing. It is such a testament to the fact that they are actually, what Justice Kennedy was writing about in Obergefell, calling out in the dark, calling out, and that right has been taken from them. If Sandra gets sick and is in the hospital and really, really needs her husband to sit by her side, which she had COVID very badly, she's had, health issues, her husband can't be there. And so to answer your question, I don't know. I guess I don't know if they know. I mean, we're all still just totally, not that we were not expecting this, which is why we tried so hard to keep this out of this court, but it's still shocking what this government has done to this couple.
To be clear, we are a week out. It's a raw interview. You and I both wanted to do this.
I guess my appeal would be to people who are listening is, honestly, we need help. I wish I could sit here and say we have some great plan now to get them reunited, but there's no appeal from the United States Supreme Court. If you have connections and you're listening to this, if you know people at USCIS or in the administration or in Congress, I mean, please reach out. We need this is such an injustice which has happened. I mean, can I just say quickly, the story of Ellen Nauf?
No.
The Nauf against Shaughnessy case is heavily relied on in the decision.
Yeah.
That was a case where I'll be quick about this, but basically, war bride, Czechoslovakian.
The World War II guy, right? That was an interesting discussion.
And the government wouldn't let her in under the predecessor. I think it was 212 A27 or A28, which was the predecessor of the same statute, any other unlawful activity. And they thought she was a communist because they thought they had somebody who ratted on her and said that she was a member of the Czech Communist Party. She sued. She lost to the Supreme Court. And later, through whatever means, they were able to secure a hearing, and that it became clear that the evidence that was being used against her was completely wrong. That it was a factual that the guy who had ratted her out, I think, was a known perjurer who, the FBI didn't use anymore, that she didn't work at the embassy at the time that the communist who they thought that she was, I mean, you get the flavor of the times in just the way I'm describing the case, but she eventually got in. And so if there's anybody out there, I'm appealing, email me. We need all the help we can get to make this right. And we're not done fighting for this couple or couples like them, but
it was a great find of a case. Reading that discussion, Justice Barrett really had to distinguish that. She kind of flipped it on its head by saying even there they weren't let in. And if I'm not mistaken, it ends up going all the way up to the Attorney General back when it was a much smaller government. And that was because of the overwhelming support of all of the veterans, right? And all of the veteran supporters, and the Attorney General was like, you know what, I gotta do something about this. So you're absolutely right, and that was a heck of a find of a Supreme Court case to help your position. Where does the doctrine of consular non-reviewability go from here?
Well, we'll find out. I mean, there's going to be litigation. This is not over. There are a lot of avenues still, we think, to challenge. We're going to be fighting more on this front. I mean, this is a battle. We lost the battle, but we did not lose the war. And it's gonna. I think, though, honestly, what's really going to change, and maybe I'm getting a little bit out of. I don't want to grandstand or anything, but the legal system in this country is not going to change until there is a profound change in the political system overall. And the fact that this court has been allowed to run amok, the fact that we have a presidential election between two candidates who have been scrambling over each other to issue the most right-wing tax on immigration, especially in this current administration's case at the border. Something's got to change. This isn't, primarily going to be resolved through the courts. This is a fight about family unity and about due process and the defense of the Constitution and the defense of immigrants at a time when they need support. My family background is kind of interesting. One half of my family has been here since the 17th century. Lee, the other side,
which Lee?
No, well, fortunately not that. Fortunately not that Lee. That has been, but and the other half is Norwegian immigrants in Oakland, California, and so I just think there has to be much more of a political sense of the defense of immigrants. It's not going to be done through either of these parties. I'll tell you that. Again, that's my own personal political opinion, but I think it's important. There's no other way to. Otherwise, you can't just tell people that this is going to get resolved in the court system, because look at what's happening all over. And there is a constitution, and to the extent that we can still go to court and fight for it, we have to. Absolutely.
We've been talking for a lot of time. I want to hear what your arguments for round 2 of the doctrine of consular non-reviewability are, but I think we're going to have to postpone that. I'm very interested, and maybe I'll be reviewing that on a future podcast episode, and then I'll send you an email and ask for your behind-the-scenes thoughts. I've really enjoyed this, but it's been a bit negative, and that is a reflection of the severity of what we're talking about and the rawness of a personal story just lost. So if you could indulge me, could you describe what it was like just a bit to argue before the U.S. Supreme Court in a vacuum? All the preparation, I'm sure, nearly killed you because it is so difficult and so labor intensive. But being in the Supreme Court and doing that, I mean, what was it like? I'm interested to hear anything you have to say on that.
All right. Well, two things quickly. First, number one, I mean, the level of preparation was not all mine. I mean, seriously, I'm not saying this to be falsely modest or anything. The people who worked on this case at the Supreme Court, Chuck and Karen and the NIJC team and everybody. I mean, this was not if anybody else out there wins an appellate decision or loses one and tries to take it up and it gets granted, this was a totally exhausting experience. If it wasn't for my wife, who literally took care of everything around the house for like 7 months while I was doing this every day and only this, and if it wasn't for my boss, Alan Diamante, who took cleaned my docket, except for this, looking back on it, I mean, it was extremely stressful. It was extremely rigorous. And, I just knew that we were right. And that was kind of what kept us going. I didn't know that the Supreme Court was going to know that we were right. But yeah, I mean, there was a moment where Justice Jackson was asking me a couple of nice questions at the very end there when I was done sweating through my suit and looking up at the ceiling and I mean, they're very close to you, these guys, these justices. They're 10 feet away from you. They can see your notes. I don't know. I wouldn't say it was intimidating because I knew that we were there for a reason. I mean, there's a lot that's happened in that courtroom, a lot of good things, a lot of bad things. And to have been a part of this case is an honor. It was an honor to represent Sandra and Luis, and it's difficult to feel. I know you're saying don't end on a negative, and so I'll try not to. It's difficult to feel as though the future in this country, given the way things are going, especially given the prospects of the upcoming election and the choices and the potential outcomes, that much good is on the immediate horizon. But I do think that it is, because I do think that these types of cases bring attention to the fact that there is a lot of opposition all around the world over the injustices that are happening. And that's going to change things. That's going to change the way that people approach their own lives, the way that they approach politics. It's going to change the way judges approach the decisions that they make at the bench. And ultimately, that's the only thing that's ever changed anything in history. I mean, that does give me hope. But yes, right now I'm very angry. I'm very angry at the outcome of this case. But I'm confident also that we have very, very good people. We have very smart people on our side. We have to work together. We have to increase our collaboration. We have to be more coordinated than the federal government, which maybe isn't as difficult as it sounds. But no, I mean, let's work together. There's a lot of cases out there ready to be fought, and it was never something that I wanted to. I never wanted to be arguing a case before the Supreme Court. That this has never been a dream of mine, But once it really got going, it was to be a part of history. I mean, what can one say?
I think you've said a lot, and it's been very enlightening, and you said it very well. I listened to some oral argument, and you did an excellent job, and you're clearly the right attorney for this case. I will end on a positive note, and that positive note is congratulations to you and everyone who you've mentioned and not mentioned who put together an amazing fight, and to Sandra and Luis for saying, you know what? We're not going to just take this, and for doing it, and for getting a win at the Ninth Circuit, and for taking it to a hostile Supreme Court, for not laying down. Congratulations to everybody. It's not the result anybody wants on your side. There is something to be said for fighting the good fight, and like you said, when you're right on the facts, for taking that fight. So congratulations to the immigration bar, Sandra and Luis, and everybody for taking this fight and getting the Supreme Court to say what it actually thinks. If this is the country we're going to be, to stop beating around the bush with Kennedy concurrences and reasons for not doing it. If that's what we're going to say, if that's who we're going to be, that's who we're going to be. And now we have a decision to make whether the American people want that to be who we're going to be, if we're going to legislate away the doctrine of consular non-reviewability or take other actions that you were mentioning. So the positive note for this very enlightening interview is congratulations for that.
Thank you, Kevin. And thanks again to everybody out there who played any role, ever touched on, or who thought good thoughts about us. Thank you to everybody.
Thank you for being on the show, Eric. Thank you for spending your evening with me. And please pass our well wishes on to Sandra Luis. Have a great night.
Thanks, Kevin.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.